When we take up this matter, especially the teaching of international law in the Indian universities, much has not improved. It is not improved for the simple reason. We have been teaching in most of the universities a paper which is known as Public International Law. And in the recent past, with the direction of the UGC or someone, we spoiled it. And we have put in for Public International Law, along with this paper, human rights as well. When human rights is being put along with Public International Law, in a course of 4 months, in a semester, neither the teachers are able to do justice to human rights, much less to Public International Law. This is a major lacuna. Now, the second important thing that is being pointed out at times, most of the scholarship in international law in this country, supposed scholarship, not real scholarship, is produced by people who are masters in the area of environmental law. And a majority of them are scholars in the area of human rights. So when they are scholars in the area of human rights as well as environmental law, there is no scope for the development of real international law as well. Hardly. I can just tell you, if you look into the JNU professors, from the time of the appointment which was made by Professor Parsarathi for the first Vice Chancellor of JNU, he brought the best of the people. And when I speak of the best of the people, remember Professor R.P. Anand. He was a professor of international law at JNU. Many of you may not be knowing, at least those who have read about his biodata or CV will come to know. Professor R.P. Anand was an LLM from Delhi, LLM from Columbia, and a Doctor of Juridical Sciences, SJD, from the University of Wales. And he has worked in different universities before he came and became a professor of international law at JNU. He was the man who worked on the origin and development of the law of the sea at the East West Center, Hawaii. And when such people adored or made professors of international law, naturally the credentials would go up of the university. And the other person happened to be Professor Rahmatullah Khan. He was a professor at Woodrow Wilson Center for Scholars, a regular visitor to the Max Planck Institute, and he was a regular professor who used to visit to various research centers and work upon. This person who became a professor of environmental law at a later stage, a professor of international law becoming a professor of environmental law at JNU, when 2 chairs were constituted in JNU, one in space law and other one in environmental law. The third person happened to be Dr. Mani. Mani was advisor to the Kingdom of Bahrain, the Kingdom of Nauru. And as an advisor to the Kingdom of Nauru, his reputation rose to dizzy heights. And he became the cabinet secretary to the government of Nauru. Thereafter, when there was a dispute between the state of Australia as well as the state of Nauru relating to the sharing of the phosphates, he was the man who was the counsel before the International Court of Justice in favor of Nauru, and the case was won by him. I am just putting you across, where are these type of scholars? See, I happen to be a product of JNU. I did my PhD, MPhil PhD under Rahmatullah Khan. And when Rahmatullah Khan became a professor of environmental law, I was the first PhD in environmental law. Now, most of the scholars, remember, who have produced PhDs either in human rights or in environmental law are not real scholars in international law. That is the point I just intend to drive home. You just think of Professor R.P. Anand. He was the one who delivered recall lectures at the Hague Academy on sovereignty of states and international law. He was invited twice to deliver this lecture at the Hague Academy. Now, these are the people who actually developed the subjects. In the recent past, we have another scholar who is known as Professor B.S. Chimney, Bhupendra Singh Chimney. Now, Chimney is also retired. And in JNU, which is supposed to be a center of international law, we have hardly any scholar worthy of name and worth the name. This is the sad state of affairs in the area of international law. Now the point at issue is, you may put a question, what if, you mean the scholars who have mastered international environmental law or human rights are not capable of becoming scholars in the area of international law? The issue that is being told by Professor V.S. Chimney, they are not able to appreciate and understand the different perspectives of international law. When they are not able to understand the different perspectives of international law, remember, it is limited. Their understanding is naturally limited. I am just telling you one more thing. I have just, since I have done my PhD and worked in the area of international environmental law, I have been watching or going through several PhD theses which is being produced in international environmental law. In environmental law, today, we have a principle which is being developed, and this principle is called as the principle of no harm rule. Now, no harm rule today has acquired the characteristics of a customary rule of international law. Now, whether any scholar or any teacher who teaches environmental law makes a reference to this principle in the classroom. Now, no harm rule of international law started first and foremost in a dispute between the state of Canada and United States. This is known as the Trail Smelter Arbitration case. Now, after it started, remember, in a series of cases starting from Corfu Channel in 1949, then you have the other arbitration case which was decided between the state of France and the state of Spain in the year 1957. Remember, they came up, and in the nuclear test cases, it was reaffirmed again. And remember, up to 2007, 2010, series of cases were decided by the International Court of Justice. Now, in these cases, in the 2010 case happened to be the pulp mill case between the state of Argentina and Uruguay. Now, a point at issue is whether this is taught in the classroom, real principle of international law. Now, states have the sovereign right to do what they want. But when the states have the sovereign right to do what they want, they are not supposed to harm the interests of other states. Environmental damage to other states cannot be done. Today it has become a customary rule of international law, whether it is properly taught. You are interested only in teaching air law. You are only interested in teaching the other laws which are enacted by the concerned government, which may be the central government or the state government. Thus far, no further. Real principles of international law is undermined. And the importance which ought to have been given is not given to the concerned subject. This is what most of the scholars who speak of international law point out. Now, the other thing that is being harped upon is, in the syllabi that is being provided, approved by the Bar Council of India, as well as at the LLM level, approved by the University Grants Commission, you just take into consideration LLB course. In the LLB course, you have public international law, and this is principles of public international law and human rights. The same paper, today it has become like that. Now, along with the other papers, are there any foundational courses which are being given to the students? And if these are the foundational courses, which are they? Now, generally, in a few universities like the national law schools, the foundational course that is being given is international organizations. It is relating to United Nations. The second one is relating to the maritime law, which is being recognized as a paper. Now, the third one happened to be the law of the sea. Now, the fourth one is human rights. Now, law of the sea, human rights, and other two papers which I have just mentioned are the papers which are given at the LLB level. And thereafterwards, remember, LLB is closed. Most of the LLB papers today, especially which is being taught in the national law schools, encourage the students to make a career in what we call as corporate law. Now, when importance is given to corporate law and to make a career in it, naturally the scope and the importance which ought to have been given to international law is denied, and it is not given at all. Now most of the teachers, remember, they are interested only in bringing people who are supposed to be experts in corporate law. Because students are also thinking of making huge money, fast bucks, and disappear. In the corporate law, most of you may not be knowing, remember, there will be what we call as jump and jump only up to a particular period. Afterwards, you have to see from downwards, not upwards. This is a fact. After 10 years, there will be no growth in corporate sector. It is a fact. People, if you don't know, I can tell you hundreds of the people who have gone to the corporate sector, there is no growth. But whereas in international law, it is the ulta. Growth can be any. See, I am an ordinary scholar. I became an advisor in the cabinet. I am not praising myself. It has come because of the hard work which I have done by me. To the kingdom of Bahrain, not for 1 day or 2 days, 8 years I served. And if at all I have made the money there, I made there only. Not that I have not become an academician here. I have become the best of academician and professor and a vice chancellor as well. And if at all, remember, anybody speaks Subramanya means international law, nothing. Where? I don't know anything about company law. The company law which I have studied is the studied law in the year 1974. Afterwards, I don't know. Only for the sake of students to tell something, we say it is amended in the year somewhere after 2010. And that company law does not exist. See, this is what is required. And it is the duty of the teachers who have studied to encourage the students of the present day generation to take up to international law. Now, the other aspect I just wanted to tell you happened to be the attitude of teachers have not changed. The attitude of teachers have not changed for the simple reason today, even today in the classroom, a teacher who teaches international law will take up one issue and keep on speaking the whole semester. And this issue is whether international law is law or not. Nobody can deny this, whether international law is law or not. And what is being said by Austin? What is being said by his forefathers, Bentham? No, international the law is the vanishing point of jurisprudence. And this is the discussion that takes place. And no teacher, when he speaks, he just takes into consideration the universalization of the application of international law at the domestic level. What is important for a teacher is to say that international law is a universal law. A soft law is nonetheless a law. Generally it is called as a weak law. A weak law is nonetheless a law. But then it has universal character. There are plenty of areas today which have achieved and attained the status of universalization. Now it is the duty of a teacher to bring you home and tell it. Now some of the scholars go to the extent of pointing out, when they speak about the interrelationship between international law and municipal law, in international law you don't have compulsory jurisdiction. When there is no compulsory jurisdiction of a legislation which is enacted at the United Nations level, which is called as the centralized legislation, it is lacking binding effect. Lacking in binding effect. So when there is no binding effect, remember, international law need not be observed at all. It need not be adhered at all. It is just, remember, a time passing law. That is the way interpreters go on and go to the extent of finding out. But then it is not the real situation. There are scholars who go point out, especially Anthony D'Amato, the Italian scholar, and his an authority in international criminal law, who points out the basic presumption, especially the doubting quality amongst international law scholars, is you don't have binding precedents. When you don't have binding precedents, remember they say, the scholar would say, since it is not binding, should we adhere to? Should we accept to? Should we enforce it to? And it is for what reason? And it is the duty of scholars to say it is not the way. Now, for example, how many laws have been enacted in the area of international criminal law? How many of them have been ratified by more than 100 states? And when it is ratified by more than 100 states, remember, A state which has signed a particular treaty cannot go to the extent of saying it is not binding on it. Because act of ratification is an act of municipal constitutional law. When it is done through the constitution of a particular state, it had to be adhered, it had to be accepted, and there will be a binding effect. Now you take illustrations, for example. In the recent past, you have conventions which are being adopted by the international community. And these conventions which are adopted by the international community go to the extent of speaking that international law is a law. And remember, in the event of violation, the matter will go before international tribunals. Now you take the instance of the Law of the Sea Convention of 1982. And the Law of the Sea Convention, although it was enacted in 1982, came into force in 1994. That is the lethargic attitude of states. Although it came into 1994, now how many disputes have been resolved and adjudged by the International Court of Justice? How many cases have gone before the Law of the Sea Tribunal? Please tell me when I am supposed to stop, otherwise it will go on. Now, how many cases have gone before the Law of the Sea Tribunal situated at Hamburg? And Law of the Sea Tribunal has decided plenty of cases between states. And these cases have come before the tribunal only after the convention was adopted. Now prior to this, the matter has been decided on between several states by the International Court of Justice. See, for example, the sharing of waters between states, between the states relating to the continental shelf. In 1969, the continental shelf cases was decided between the state of Germany, Denmark, and the other state. Now when it was decided in 1969, for the first time it adopted the equitable doctrine. The equitable principles of application has to be adhered to compulsorily by states. When it was indicated in 1969, look to the subsequent judgments. Now one is between Libya and Malta, and the other one between United Kingdom and Turkey. Now there are plenty of cases relating to the sharing of the continental shelf between states. In all these decisions, the International Court of Justice went to the extent of pointing out that this principle of equitable principles, which was decided in the continental shelf cases between Germany, then Holland, as well as Denmark, are to be respected by states. Now then what else binding effect is required? Now in 1949, the International Court of Justice pointed out the international organizations have a personality of its own. If they have a personality of its own, it can sue as well as be sued in its own name. Now when once what we call as the personality is decided, United Nations has a personality of its own, should this matter be decided again? And it is decided and it is being practiced. Now most of you may not be knowing, most of the teachers are not in a position to harp upon issues which they are supposed to tell the students when they teach the subjects. 2 instances I will give you. That would be enough, I think. Now one issue relating to the area of human rights. Most of the teachers teach subjects relating to human rights. When they teach human rights, what ought to be taught is not taught. Now first one is the development of the law of human rights began from 1807. And thereafterwards, remember, after the Battle of Waterloo, most of the European states came together and they decided that they should have a branch of law known as the human rights. Then after the Berlin Congress 1878, most of the rules relating to the law of warfare started developing, and resulting in the culmination of the Red Cross Conventions of 1949. Now I just intend to tell you only one important aspect relating to this. See, the human rights law grew, and that was responsible for the United Nations to develop the law of human rights. When the Second World War broke out in 1940, 1939 the World War broke out. In 1940, three heads of states, Stalin, Winston Churchill and Roosevelt, were in a battleship in the Atlantic. When they were in a battleship in the Atlantic, President Roosevelt makes a declaration. Today, that is in 1940, there are dangers for the state of Germany in not protecting the basic four human rights. Now, which are these basic four human rights? One right happened to be freedom to worship God. Millions and millions of Jews were attacked, tortured, humiliated, snubbed, eliminated. This was the attitude of state policy which was pursued by Adolf Hitler. Now the second one is freedom of speech and expression. That was in danger. Freedom of the press was in danger. And freedom, as I just indicated, peace. Where was peace? And these rights, when they were in danger, they said there is a need to protect these rights. This has taken place in 1940, and immediately on March 6th, 1941, they convened a conference, and in the conference, President Roosevelt as well as Winston Churchill, they said, freedom to worship God and freedom to live in peace are to be respected by everybody, and this cannot go. That is where the Charter of United Nations, which when it came into existence in 1945, they went to the extent of pointing out, we the peoples of the United Nations. That means what? The Charter of United Nations not merely speaks for government, it speaks for the peoples of the world. Whether any teacher teaching international law makes a reference to this. Then I just speak to you the binding obligations of the Charter of United Nations. When we speak about Article 13, 55, 56, these are the three articles which speak about human rights and its binding nature. Now there was a discussion which went on between scholars. Manly O. Hudson was a member of the International Law Commission. He said that Article 1, paragraph 3 as well as Article 55 and 56 of the Charter of United Nations is only an aspiration to achieve and to be achieved. And you cannot read beyond that. If you read beyond that, the whole Charter of United Nations will disintegrate. If you say the human rights provisions indicated in Article 1, paragraph 3, 55, 56, 76, 3 as binding obligation, the whole human rights, the Charter of United Nations will disintegrate. But then there was another group. Another group was led by Professor Harsh Lauterpacht. It was led by Professor Philip Jessup. And Philip Jessup as well as Harsh Lauterpacht, they just pointed out, no, it is not the case. Go to the intentions of the makers of the Constitution, that is United Nations. And the intentions of the Constitution makers, that is the United Nations, are very clear. They said certain provisions for the protection and promotion of human rights must be binding, and it has to be accepted and it has to be adhered. Philip Jessup is a man who just points out, along with Professor Quincy Wright, you look to one provision under Article 56. States are supposed to protect human rights and not to discriminate, not to show any kind of discrimination based on religion, sex, place of birth. They are supposed to adopt joint and separate action. What does it mean? Adopting joint and separate action by a state along with the United Nations gives the character of binding obligation. See, he is quoting the provision and pointing it out. States are supposed to adopt joint and separate action for the promotion and protection of human rights. This clearly conveys the message that the Charter of United Nations and its provisions on human rights are binding on all states. But then there was another scholar in Hans Kelsen. Hans Kelsen is the man who said no. It is not binding unless an amendment to the charter takes place. It is not binding. It is not contemplated. An amendment has to take place. Now, point at issue is it is the duty of a teacher to bring home when he teaches human rights these aspects. Unless these aspects are brought to the classroom live, remember, he will not be in a position to speak anything on the European Convention of Human Rights. See, for example, no teacher in a classroom makes a reference to the development of human rights after the establishment of the Charter of United Nations. Now, the Charter of United Nations came in, but then when it came in, Lord Denning gave a judgment in England. And he said, he delivered the judgment after the Universal Declaration of Human Rights was adopted. This person, when he was interpreting the Universal Declaration of Human Rights, just said, Universal Declaration of Human Rights is a useless document. It is a useless document for the simple reason it has no litigants under it. No cases can be booked under the Universal Declaration. No FIR can be filed. No person can be arrested. And no official authority is being provided under the Universal Declaration of Human Rights. When he said like that, the very next day, remember, the United Nations Secretary General convened the United Nations Office of the United Nations Commission of Human Rights. Having convened the officers of the United Nations Commission on Human Rights, he just requested them, please draft a convention, United Nations Convention for the Protection and Promotion of Human Rights. That is where the civil and political rights came in. By 1952, the draft was ready. But then states, remember, were always boasting about their sovereignty. Because of the sovereignty and the superiority of sovereignty, they could not have a convention on human rights until 1966. That was prolonged for another 14 years for its ratification. That is the attitude. Why? 1966 it was adopted, but then it came into force in the year 1976. That is the attitude of states. Now these are things which are to be told. I am just telling you. And even in international law, it is the same way. The attitude of scholars teaching international law is not to give importance to this. It is a subject wherein, remember, scholarship is made. Now today, when we speak about universalization of international law, you think about the subject like law of the sea. The rules relating to the law of the sea is binding on everyone. Now think of the commercial arbitration. Issues relating to commercial arbitration has been accepted by everyone throughout the globe. And today, remember how many arbitrators are produced in the last 10 years, how much money they make, where they go, where they practice. I still remember when I was working in Bahrain, the minister for the government of Bahrain, especially Minister for Law and Justice, he went to the extent of pointing out, we want to have a center for commercial arbitration in the state of Bahrain. See, the purpose of telling this, if Bahrain, a small state, has adopted, almost all other states came forward to establish a center for arbitration. Now, if this is relating to commercial arbitration, what about space law? What about international trade law? Now, these are areas wherein, remember, along with politics, law also has a role to play. So one writer was just making a reference to saying most of the trade law issues are related to politics and economics. And law has no role in it. Even if there is role for the development of law, it is only a lesser. That is true, but then the law has grown. For example, because of the convenience of state parties, whole international trade law has gone up. And the nitty-gritty issues are to be pointed out and should be brought home. I was just reading an article which was written by Professor Chimney. The Asian perspectives of international law. Now, in the Asian perspectives of international law, Professor Chinmay was saying the time is ripe to unite the Asian, African and the Chinese economies together. If China, India and ASEAN if they come together and accept and formulate rules of international law, this can become what we call as universalization and universal rules. Now, what he was saying was, under the pretext of accepting and becoming parties to BRICS, and the other group which is known as the 21 group, wherein you have the developed nations. Remember, we are promoting oligarchy, not the protection of rules of international law. Instead of supporting oligarchy, why not we contemplate the development and rules of international law is the question which he has put to the readers. With this, I thank you for giving me this opportunity to share a few of my thoughts with you. Thank you.